Hi, folks. Denise Howell here. And next up on This Week in Law, we have a fabulous panel for you, including Jerry Brito, Antone Johnson, Evan Brown, and me. And we're going to talk about Groklaw, ungrokking. We're going to talk quite a bit about Bitcoin. If you don't understand it yet, hopefully you will by the end of the show, and also the legalities around it that are of concern to policymakers. And we're going to spend a good deal of time on the privacy developments of the week. Who's watching us? Everyone, apparently. Hopefully you are too. Next on This Week in Law.
Netcasts you love.
From people you trust.
This is Twit.
Bandwidth for This Week in Law is provided by CacheFly at CacheFly.com.
This is Twill, This Week in Law with Denise Howell and Evan Brown, episode 224, recorded August 26, 2013. Better call Saul. This episode of This Week in Law is brought to you by ProXPN. ProXPN is a virtual private network that allows you to use the internet the way it should be, anonymous and unfiltered. For 20% off your new account, go to proxpn.com/twit and use the code TWILL. Hi, folks. I'm Denise Howell, and you've joined us for This Week in Law. We've got a great batch of stories to talk about today and some really smart people to do it with. Joining us once again on the show from the Mercatus Institute and George Mason University in Washington, D.C. is Jerry Brito. Hello, Jerry.
Hello. How's it going?
Going well. How have you been?
Very good. Hanging in there.
Good, good. Am I getting your name right? I always think, is it Brito or Brito?
I don't know. Yeah. So it's actually the Mercatus Center at George Mason University, and it's
Yes.
Jerry Brito. But that's
Brito.
I get
There
it
we
all
go.
the time. Yeah. Not a
There we
problem.
go. Have never
He is
visited.
quite bright.
Yes, yes. I've never visited the Mercatus Center, but have done a lot of reading with the copious stuff that you guys put online, and it's always worthwhile, and we're going to touch on some of that in the show today, so welcome back.
Great. Thank you.
Also joining us for the first time is Antone Johnson, who is a lawyer who has been around the internet world for quite some time, having done stints at both MySpace and eHarmony. And I think you started out your career at Wilson Sonsini. Is that right, Antone?
Yeah, and then Excite after that. I'm one of the old veterans of the internet.
Yes, very old school. So you have been there, done that, and know a lot of stuff at this point.
I'd like to think so.
Yes. Well, it's great to have you on the show. Also joining us from Chicago, Illinois, and the Info Law Group is Evan Brown. Hello, Evan.
Hi, Denise. How's it going? Looking forward to our conversation. This ought to be a good one. Really some compelling topics today and some interesting things going on. So, Antone, nice to meet you. And Jerry, really nice to talk with you again.
Nice to see you.
Likewise.
All right. Well, let's start out. There's been a lot of developments this week on the privacy front. So let's start there. All right, we have a couple of stories this week that involve, for lack of a better description, ritual seppuku of one kind or another. And the first one, very sadly, comes from what started out as a law blog a long, long time ago, something called Groklaw that Evan and I remember going way, way back. Pamela Jones, a paralegal, started out an information service, which turned into a wonderful resource and discussion platform for following big pieces of internet litigation as they were unfolding. SCO Linux comes to mind, the Microsoft litigation in various forms. I remember LoadSys was getting a lot of coverage there. So Pamela has certainly gone far and wide and did a whole lot of work last year, too, in the copyright disputes and patent disputes involving Google. So it's been a sad week to learn that Pamela has decided to pull the plug on the site in the wake of revelations about the extent of online surveillance to which persons residing domestically in the U.S. are subject. She's decided that it's really not possible for her to have secure private communication with people who contribute and assist her in developing stories and publishing information on the site. And so she's pulled the plug. Evan, are you as depressed about this as I am?
Well, I'm more perplexed than anything. I mean, sure, we're all concerned about email privacy, but was Groklaw, or were they exchanging nuclear launch codes and stuff in all these discussions here? So, I don't know Pamela. I've never communicated with her directly, but, if we were, talking in the hallway after the show or whatever, I would say, really, does it really warrant as much of a reaction as you're giving it here? And then I'm not the only one to feel that way. Certainly folks talking about it on Twitter and in other fora, wonder if this is a little bit of a knee-jerk reaction. And her farewell post is it reveals a lot about her thinking and about her concerns about these things. And it appears that there are a number of factors that weigh into her decision to shut it down. Some things in her background that weighed into this as well. So I'm sad to see Groklaw go. I read it some. I wasn't a huge fanboy. There certainly were a lot of very serious enthusiasts about it out there and still are. So I'm sad to see it go. It's a certain landmark on the overall scape of the web and certainly the legal blogosphere. It's a very big pillar in that. So it'll be sad to see it go. But at base, I'm perplexed as to why it warrants this reaction. I'd be interested to see how that actually pans out if we ever learn anything more about it. But it sounds unequivocally like things are over at Groklaw.
Yes, it does. Although I guess some users are attempting to see if there's a way that they can go on without Pamela. It's certainly been an amazing resource for finding actual legal documents online, aggregating those and putting them together in a repository and having sort of minute by minute discussion of what's going on in important cases as they're unfolding. Jerry, have you been a fan of the site as well?
Yeah, it's been a very good resource, and I share Evan's perplexity,
Yes.
but not for the same reasons. So you're right that they're probably, Pamela probably was not exchanging, the nuclear codes over there, but to journalists, keeping their the identity of their sources secret might as well to them be as important as keeping nuclear code secret. So I can understand wanting to make sure that that's private. But if every journalist who now understands that their messages are probably being scooped up by the NSA were to just shut down, we would end up with no journalism. So I think the proper reaction to that is not to shut down, but to say, you're not going to stop me, and I'm going to learn how to encrypt, and I'm going to figure out a way to carry on my mission regardless. When you see LavaBit and Silent Circle shut down, they shut down for a very important reason, which is that they were selling what their customers believed was secure communications. And if they went on, they were putting their customers in a bad situation. So they had no choice but to shut down. With blogs, journalists, I think the proper reaction is to say no, we're going to keep on doing what we're doing, and we're going to figure out a way to do it without you spying on us.
It's not the first time that Pamela has attempted to withdraw from the site. So it seems like she's had sort of they keep pulling me back in phenomenon happen over the years. So it does seem like this has been a definitive, this enough's enough, and we're going to retire the site. It is, I don't think going to be pulled down. It will remain there, a historical piece of legal scholarship on the web. I understand it was chosen by the Library of Congress to archive as part of its project related to legal blogs. So, and it's won many an award. So it's certainly done a lot, and we wish Pamela all the best, and certainly appreciate that she is using her exit to bring attention to an important issue here. And I encourage folks to go check out her goodbye post. Antone, any thoughts?
Yeah, I mean, I just have to kind of chime in with the same, it's not unoriginal, but the same observation, which is that it really, when I first read about it, seemed like an excessive kind of reaction to, a legitimate concern, an area that has gotten a lot of press, certainly a lot of attention, a lot of good dialogue, as well as, frankly, a lot of really bad reporting and disinformation and misinformation that bears clarifying. But it didn't make sense to me that would be reason enough to completely shut down something like Groklaw. And to be honest, I haven't really used that site over the years, so I'm not that familiar with the substance of it. But with the with the general concept, there are so many other sites out there that and services, whether email providers or video conferencing, Skype, Microsoft, et cetera. We just can't live without using these, and I think that if that were the only her sole motivation, I think that would be a true shame. It sounds to me like there is more to the story than that, and that maybe have been, in her case, the last straw, the straw that broke the camel's back, so to speak. And frankly, I wouldn't blame her if that is the case. It's certainly her prerogative, but I do think it's a shame.
It's sort of been the legal equivalent of Slashdot over the years. A very discussion-rich site with a lot of information getting thrown up in a real-time way. Some of it, needing to be reviewed later on and developed, but definitely a valuable resource out there. So we wish Pamela well, and we'll continue to watch. Maybe some of the users will be able to keep the site going.
Denise, what do you think about it? I mean, when it comes to legal blogging, in the history of legal blogging, you are peerless in that regard. So I think what you would have to say about that is probably more relevant than our humble opinions on this. I mean, do you think it was an overreaction?
I don't know. I mean, I'm purely speculating. I'm not in touch with Pamela at all, but it does seem over the years like she has attempted to retire from her duties there, and has felt like the landscape of litigation required her to keep on going and keep providing the information. So, my speculation is that this was sort of a last straw kind of thing, saying, okay, well, just not going to go forward knowing what I know now. But when you read her post, I mean, this is clearly a very personal issue for her, and she feels quite strongly that if she cannot communicate with sources in a confidential way, then it's not worthwhile. She's gone to the trouble of setting up a more secure kind of email account through a company in Switzerland that she invites people to get in touch with her using that service if they have something very important to discuss that might need something more secure. So I just think this was probably a very personally motivated decision. And, as someone who has trouble getting posts up on the web these days, whereas I used to be quite prolific in writing and analysis, it definitely is more of a struggle for me personally these days. I can see where, different currents in people's lives might take them in a different direction as well. So don't really have much more to add than that, but certainly will miss Pamela and Groklaw and the work that they've done there. Including Groklaw, there was another episode of a rather dramatic sacrifice, and as I used the term seppuku earlier, this time in the form of some computer equipment, hard drives. It looks like entire computers may have been smashed at the Guardian offices in the UK. at the instigation of UK intelligence officials with the, let's see, Government Communications HQ, GCHQ in the UK, went to Alan Rusbridger, the editor-in-chief of The Guardian, and began making noises about taking legal action to obtain the information that Edward Snowden had leaked to the paper. And apparently, rather than go through that process and perhaps sacrifice their sources by having to turn over hard drives with that data on it, Mr. Rusbridger and some staffers at The Guardian voluntarily destroyed some computers. In doing so, they were monitored and photographed by folks at the GCHQ, which apparently satisfied them that their requests had been honored. The sort of silly aspect of all of this is the Guardian editor let them know, this is not the only copy of this information we have. We will go work in the United States if we have to, where prior restraint laws would prevent you from coming after this information. But that didn't stop things. Apparently, it was a voluntary decision by The Guardian, and they've gone on in their coverage of this story, their own coverage of their own story here, to say that they felt it was necessary to, they did not have Edward Snowden's permission to give this information over to any government officials, and they felt it would compromise their reporting, perhaps the security of their own staffers who had worked on stories, etc. So there's been a lot of brouhaha about this week, some all over the map kind of media coverage. Antone, what do you think really happened here?
Oh boy. I mean, this is one of my, this has become one of my sort of pet subjects of commentary for the last couple months, really, since the Snowden stuff came out. I don't want to detour too much onto the kind of meta story here, but the coverage and the disclosure of the issues in many ways is every bit as fascinating as the subject matter, the substantive issues at play. And at the same time, I'm dying to get to an open discussion of the policy issues at play, which are of great importance and of serious interest, I think, to millions of Americans, not to mention people in other countries whose communications we know flow through American networks and get stored here on our on many of our very popular cloud services and so forth. So without going too far down that rat hole, The Guardian, in my opinion, has in many ways become part of the story. And Glenn Greenwald himself, in particular, in his style of reporting, combined with his direct access to Snowden, has been a factor in that. But I wouldn't lay all the sort of blame or accountability, if you will, on Greenwald personally. I think in this case, this past weekend is an example of a pattern that we have seen in how they have gone about reporting many of these stories, where things trickle out in pieces. And when I say things, I mean facts. And I'm not talking about editorializing here. That in some cases turn out to be just completely false. Or more often than not, they're more careful than that, and there are omissions that sort of trickle out over time, and we've seen that with with the PRISM story going back a couple months, but in this case particularly glaring. The first coverage basically said government officials came into the Guardian offices and smashed computers. I mean, at least that's what the headlines were saying. And then it became clear after a little while, actually, Guardian's own people did it. And so, it's because they were forced to, with, people, I don't know what I guess GCHQ agents, operatives, standing over them, forcing them to. And then it finally became clear, okay, that's not really right either. And Rusbridger, to his credit, I think, both published and tweeted about it. and said essentially, yeah, this was a decision we made, and here's why. And we felt like, we've got copies of much of the same materials leaked by Snowden, in other countries, and there's no reason we can't continue to be digging through and reporting on that subject matter. And we'd rather just get this done, get this a problem out of our faces, get the government out of our faces, essentially, in London. And then the thing about the photo was just ridiculous. He tweeted. This is the editor of the entire paper here we're talking about. The most senior person at the organization tweeted a photo saying, "Here's the unfortunate computer that was, the victim of this smashing," and immediately tech experts looked at it and said, "No, it's not," because he had said this is the MacBook Pro. Singular, that we destroyed, to satisfy the demands of Her Majesty's government, and people immediately said, I think Ed Bott was one of the first, from ZDNet said, well, wait a minute, I see a PCI card in there from a desktop PC circa 1990 something, and plenty of others who know a lot more about tech. Were able to identify and say, well, first of all, there's no hard drives in there. And that was the first thing that they were talking about, is we smashed the hard drives and destroyed the information. There was no visible hard drive in that photo. There were pieces of what I think finally turned out to be pieces of 2 MacBook Pros and 1 desktop PC, I believe. And, to be fair, I'm not ascribing any malice here. I think what they were doing, and I think what the entire event was about, really start to finish, is about political theater. I mean, the whole thing was very theatrical, and it was done in a way to try to show, from the Guardian's point of view, are the arm twisting of the government. This is what they're making us do. And from others' point of view, the way the Guardian told the story undermined its credibility in some ways. This is a news organization, and it's not supposed to be producing theater. And people like Bob, is it Cheska? I'm not sure how you pronounce his last name, have been, mercilessly hammering on these guys now for weeks. With what he's come to call, I think very aptly, the 24-hour rule, which basically says every time a new bombshell disclosure is made by, first usually by Greenwald on behalf of Snowden, and then reported as it filters throughout other news organizations, then inevitably the story gets walked back within about 24 hours. And it turns out that, something in there wasn't quite right, or, there's another fact about it that makes it less serious than we thought, and so on and so on. And it's become such a routine pattern that he's actually, he's coined a term for it, the 24-hour rule. And I have to say, I've been following this story very, very closely now for a couple of months. I have to agree with them. I think there are other commentators that are more balanced and more skeptical, frankly, and more forthcoming when they report on these things from day one. And it's become to the point where I just don't bother reading Guardian articles. I mean, I will read others after they have read and filtered and analyzed the Guardian reports, and a wide variety of others. To me, that's just unfortunate. I think Greenwald is at the center of it. Frankly, he has a long tradition of some very vocal, very strident kind of civil liberties activism in his past, and God bless him for that. I mean, that's his cause, and that is exactly why Edward Snowden chose him as the person to be his primary point of contact in disclosing all this information to the world, because he knew he'd have a vocal advocate there, and an enthusiastic advocate there. The issue to me is, you also have someone who is behaving, I think, more like an activist than a journalist. And I really hate to get into that, old, what's become in the blogging era, tired conversation about who is or is not, a quote journalist. But I think when you're reporting on one of the most important points, in my view, of public interest and public policy of our time, and you are the central figure in that reporting with, in many cases, exclusive access to the man who is the source of this tremendous volume of material of intense interests. it seems to me there's a greater responsibility there to be a journalist and to set aside some of the, there's plenty of advocacy going around, right? Leave the advocacy to ACLU, to EFF. EFF just filed and won that lawsuit, right, where they were able to compel disclosure of some of these secret documents that had been of the Fisk court opinion, which is fascinating reading, by the way, now that it's available online.
Yeah. Jerry, what do you think about this reaction that you mentioned Lav a bit? And I kind of see a parallel here and even an echo in Pamela Jones' actions with Groklaw of people saying we're going to take our marbles and go home in the face of all this, or in the Guardian's case, we're going to smash up the marbles so that they can't be read anymore. It seems to me if they were, this does satisfy their concerns about keeping things confidential and not subject to further government scrutiny. But from a legal standpoint, it seems to me like they might be out of the frying pan and into the fire here. Destruction was not necessarily what the government was after.
Well, I guess it's not completely clear what the government was after. So I have to kind of be a little perplexed with the story too. When I first read that story, what popped in my mind was, well, again, sort of the same defiance that I was counseling for Pamela Jones is, why didn't the Guardian tell the government, no, if you want this destroyed, you come in here and take it away from us, and do raid us. And then that would, I think, have created even greater theater to greater effect. So that's always been interesting to me. And this is a story that I think had happened. This is something that happened a while back. And when this was announced, it was announced shortly after David Miranda was detained at the airport at Heathrow. And it sort of it took the spotlight away from that a little bit. But all that said, I don't think there's any question that the government here was arm twisting the Guardian about the data that it had, right? I mean, this is not the first time that we've seen governments tell somebody in possession of leaked materials, we want that material back, even though it is digital and it's impossible to get it back. So I don't think there's any question that the government was putting pressure on the Guardian to do that, and that they did threaten to go down a legal road to do that. So I'm not sure what it is that the fact that this photo had, different parts of different computers, does that mean that this is all a conspiracy, that the Guardian never really had the government come and ask them for this data and didn't really destroy his information? I think it's quite clear that this did happen. When this was written, it was written in an op-ed by the editor recounting something that happened a week or two previous. Who knows if he knew all the details about every computer that was destroyed or not destroyed, but the fact is it happened. And the fact is that the government did say, you've had your fun time, you've had your debate, it's time to stop. And that's what really we should be focusing on. And as far as, Glenn Greenwald being an activist, good for him. In many ways I'm an activist, and I don't think there's any incompatibility between being an activist and being a journalist. And I think that he is reporting information. And the same way that there are lots of other activists in the world, there are lots of other journalists who can then take the time to, in perhaps more balanced way, go through what Glenn Greenwald is reporting and confirm or disconfirm it. I don't understand what's wrong with Glenn Greenwald having a particular point of view in his reporting.
All right. Well, just tying up a couple of loose ends here, let's make our first MCLE passphrase for this episode of This Week in Law. That's a PC. We drop in passphrases at random times during the show to help people who are listening to the show for mandatory continuing legal education credit or credit in other professional fields. And if you'd like some information about that, head on over to the Twit Wiki at wiki.twit.tv. Find our show This Week in Law, and you will see a whole page on the different U.S. jurisdictions and how you can go about applying for credit for listening to the show. So that's a PC is our first one. Also in IRC, people have been asking what was the email service that Pamela Jones decided to use. It's called Colab, she says, Kolab, and it's based in Switzerland. Someone in IRC, yes?
Can I say something about that? So
yes,
I was listening, as I do religiously, to the Security Now podcast on the Twit Network with Steve Gibson, and they were discussing this. And Steve Gibson said, "Oh my word! If she thinks that's secure, it's not secure. It is not a secure email service. It is based in Switzerland, and that has, for some reason, aura of security, but it is no different than using any other email service." So I would recommend people listen to the last episode of Security Now on Twit that explains why that is not a secure email system.
And am I seeing it in a too simplified way, a too general way here to think? I mean, just the fact that it's an overseas service makes it prima facie more susceptible to NSA interception.
I think that's right. Yes.
Isn't that a big strike against it right there?
Yes, I think that's right.
Yes, good point. Hey, Evan, what do you think about the whole prior restraint issue here and the coming to the United States to do our reporting because we're going to have more freedom to keep our information and sources confidential?
Well, I think that's just a kind of an ancillary effect of all that. I mean, it's silly to think that there really is any prior restraint here because as we've vetted out pretty well, the GCHQ knew full well that there were other copies of this stuff. So that's not really going to limit the reporting to be done from Brazil and New York, like what everybody's in the Guardian UK is saying here. So I think the prior restraint issue is a little bit of a red herring or smoke and mirrors or whatever you want to call it. I mean, there's definitely something weird going on here with the whole story. And it's almost like there's a little bit of Citizen Kane journalism going on here, but perhaps even worse than how Citizen Kane was, the folks at the Guardian in the UK are interjecting themselves into the story as well, rather than just getting a few things wrong. They're actually doing it to manufacture the story in a certain way that comports with their advocacy. Sure, Glenn Greenwald is an advocate. That issue, Jerry covered that very well.
But Evan, can I say why? I mean, isn't the Guardian and Glenn Greenwald part of the story now? And it's not that they have made themselves. Is that Glenn Greenwald had his husband detained at Heathrow Airport by the government? That makes him a part of the story. GCHQ didn't seek, or the Guardian didn't seek GCHQ. GCHQ called the Guardian and said, "We need you to hand this over," because there is no First Amendment in the UK, and made them part of the story. They're the ones who came and said, "We'll watch you as you destroy these computers." So they made the Guardian part of the story.
Sure, and that's fine. I don't care. I'm not going to lose any sleep over it. I'm like Antone. I just don't really care about the Guardian all that much. Never really cared about it all that much before. I never cared that much about Glenn Greenwald. I mean, the guy hates America, I think. But what? That's his prerogative, and that's the folks who read it and give it credence. Their prerogative as well. I just think that there's something weird that's going on here, and I would make this comparison that I'm about to make, even if it weren't for the UK. It's even particularly more appropriate here. If you remember that scene about 2/3 of the way through Monty Python's Search for the Holy Grail, where King Arthur and one of his knights are trying to figure out who lives in that castle, and he's talking to the peasant, and he finally, gets the peasant all, worked up on some political issue, and at the end, he actually, lays hands on the peasant, and the peasant says, "Come and see the violent inherent in the system. Help! I'm being repressed." I mean, that's what's going on here. And add that to some Citizen Kane journalism, and you've got you got a lot of copies of stuff to sell, a lot of eyeballs to look at ads. So sure, it's part of the story. It is what it is. Who am I to critique anybody's journalistic scruples?
And for those of you playing the This Week in Law drinking game, I think that you all just got to consume with our first and possibly not the last Monty Python reference of the show. That was awesome, Evan.
Yeah, thanks.
Yes. Let's move on to some details that have emerged this week on the scope of NSA surveillance. It's actually just sort of painful to read. There's a Wall Street Journal story outlining the broad reach, broader than even anticipated before, with emails being stored and definite a lot of domestic information getting swept in more so than even was anticipated before. And also, as Anton referred to, the now public order from 2011 of the Fisk Court that determined there were thousands of instances a year when the NSA unintentionally collected purely domestic communications. In the face of all of this, it's easy to see why some people are choosing to pull the plug on services that they either are holding out as secure and confidential, or that they simply wish could be that way. Do we have any thoughts, collective or otherwise? Let's start with Jerry on the new information about the scope of the surveillance.
Well, I mean, at this point, all these new revelations about what is being collected from whom, how it's being stored, at this point, I'm just going under the assumption that everything that I do online and anybody does online, you should just go under the assumption that it's being watched. And I think that maybe is we know that's what led Groklaw to shut down. It's just the oppressive sort of feeling that your government is watching what you're doing, and that you may, at a future date, because again, if this is being held for a long time, at a future date, you might be held to account for something. I think it's very troubling. I think we're going to continue to see more revelations about what is being collected. I think what that does is, number one, it has a chilling effect on speech. But number two, I think it also shows how our government has lied to us, right? Because with each new revelation, another part of the sort of justification for this falls apart. So I don't know if that makes me anti-American, because I think that way, but yeah, I mean, I'm pretty concerned about it.
I certainly don't think so. And I think, there is definitely a need for at least more transparency from the government, and not from simply people who are whistleblowing and others who are doing reporting on the way that these processes are unfolding. It certainly, causes people to question the integrity of the government, which I think is a very unhealthy situation to be in. What the Wall Street Journal reported on the 21st was that 75% of net traffic is searchable, that the written content of emails is kept, that there's filtering of domestic calls made with internet technology, and a whole lot more incidental collection than had even been reported earlier. Evan, do you think that we're hitting a breaking point? Obviously we've talked a lot about the tension between, the National Security Agency has a job to do and needs the ability to operate in secret and gather intelligence in a way that's going to enable them to do their job. Do you think we're hitting a breaking point, though, on how unfettered their reach should be?
I mean, if we're not already at that breaking point, then people haven't been paying attention and haven't had a pulse for the last few months. So of course we're at a breaking point. It used to be, I mean, there was a real sea change with at least on our discussions here on the show and in the general media, and just kind of people's general sentiments, at least as far as I can gauge what people's general sentiments are, being a member of society and just talking to people. There was a real sea change with Snowden and the revelations and all that that happened here. And it's an incredibly difficult problem to solve because of this perennial tension between the importance of national security and the need for secrecy that's occasioned by that. And so because of this secrecy, we can't really get in, and it's difficult to learn about all these things, and it gets right to our sensibilities. And it just seems like every day there are new revelations about domestic communications being swept up into all of this. So, I don't know what it means to be at a breaking point, because what is it that's really going to break? Are we all just going to, go crazy and, run out into the streets and, just give up on it all? So what does it really mean to be on the breaking point, I think, is the real issue. What the only reasonable way of going forward on all this is to stay vigilant, stay persistent on the concern about it, call for legislative changes, call for real oversight, not agencies auditing themselves and looking at what they may have done and may have not done well. I mean, James Clapper shouldn't have the ability to say that he did a good job. Just that's what really has to be done here. So characterizing in terms of a breaking point, I think we've been beyond the Rubicon for a while.
Right. Antone, do you think that the public is at a point where more, everyday people are going to go the route of Pamela Jones and try to select services? You've been with a lot of internet companies that may address these issues.
Well, I think certainly some subset of the public will. I think there's no question the consciousness has been raised in a way that it hasn't been to this degree before, and frankly, a lot of us, I think, believe should have been back when the Patriot Act was being debated, and the FISA amendments, the Protect America Act, and then the FISA amendments extension, and then the other extension. All these opportunities where some groups, to their credit, were out there. And some individuals were out there kind of sounding the alarm bells about what Congress was approving. And for whatever reason, those things didn't seem to really get traction with the general public. I think, so I have my personal opinion on why that is that most folks aren't all that concerned about the concept of Uncle Sam or Big Brother doing the wrong thing with their personal information. If anything, they're far more concerned with what Facebook or Google or Yahoo or Microsoft is doing with their information. And yet, even then, it's been a struggle, as those of us who do things like write privacy policies for a living know, to get anyone to even click on them and read them. And I think that is primarily a trust issue and primarily a reputational issue. And so we have, so at last we've got a spotlight shined on this particular issue of government data collection, when in the past, to the extent I think people have really gotten riled up about what is being done with our information and what can we as consumers and as citizens do to control that and to curtail that, it's been mostly about business and what they're doing, ad tracking, opting out from things like that, right? Do not track and so forth, and cookies and behavioral targeting and all that good stuff. And I don't think that's a mistake. I think that's all very important discussion to have and to educate people on. So anyway, that's a bit of a digression, but I think that the subset of the public that is or has become now as a result of these disclosures had a heightened sense of awareness and attention to those issues. That subset of the population, I think, will be interested in looking at a variety of tools and methods and techniques technologies to try to make things safer. Well, I think we should all probably realistically acknowledge that, as the public health folks will say about safe sex, they don't call it that. They call it safer, because there's no such thing as 100% safe. I hope that was okay to say on the family show here.
Yes, of course. We're all about having a safer internet. And in fact, now would be a good time to take a break. We're here with Jerry Brito and Antone Johnson and Evan Brown and me talking about privacy and security developments in the last week. And we're going to get on to some other tech law stories, including potential liability for hiding your IP address. But if that is something that you might be interested in doing for very legitimate reasons, then you should check out our sponsor, ProXPN, which is a virtual private network that works with almost any internet connection. Now, this is a great way to at least have a safer internet. As Anton was pointing out, and as we've been discussing here on the show, nothing is going to be 100% safe, but you're going a good long way towards safety when you create a secure encrypted tunnel and send all of your online data through that. You can use any application with ProXPN, including your browser, email, file sharing, instant messaging programs. It keeps everything you do online hidden from prying eyes, disguising your physical location and giving you unfettered access to any website or online service, no matter where you live or travel to. So it's a really good alternative for many things that you might be interested in doing. If you are concerned about the 6 strikes regime that is in place in the U.S. and you don't want to get caught up in questions and proceedings with your ISP over your online activities, a VPN is a great way to go. Also, you know, we've constantly got issues about CISPA and HIPAA and various legislation that may rear its ugly head again. And ProXPN is a great way to deal with those kinds of situations. Gives you complete online privacy through a 512-bit encryption tunnel. It works over OpenVPN or PPTP. You get to choose. You can protect yourself against that 6 strikes rule, keep your personal internet usage private at work, bypass filtering and blocked websites, bypass geographical restrictions for internet content and online video with worldwide servers in the United States, UK, Asia, and more. It makes your internet connection region-free. It works for both Windows and Mac, so if you're like the Guardian and use both, you can have the advanced controls that ProXPN makes available, allowing you to select the programs and ports you want to anonymously route through its servers. It also works with your iOS or Android device, allowing you to use your data plan or public or corporate Wi-Fi with complete and total privacy on the go. There's a new ProXPN app for Android in the Google Play Store that supports OpenVPN. It has world-class customer support, and unlike the email program that we were mentioning earlier, Steve Gibson loves this product. You can check out his great review of it on Security Now, episode 400. So go to proxpn.com/twit for more information and to sign up. ProXPN premium accounts are normally $9.95 a month or $74.95 for the entire year. We've got a special offer for you, though. Go ahead and use the code TWIL, and you'll get 20% off for the lifetime of your account. That's less than $5 a month on the yearly plan. So if you're not satisfied, you can cancel within 7 days for a full refund. Go to proxpn.com/twit and sign up with the code TWIL, T-W-I-L. Thank you so much, ProXPN, for your support of This Week in Law. Now, the story I was alluding to about masking your IP address comes from the Northern District Court of California and is the 3TAP case, Craigslist versus 3TAPs. And this has been going on for a while. We've talked about it before on the show, that Craigslist is quite concerned with the scraping that 3TAPs is doing of its site. Craigslist is asserting proprietary interests over all content on the Craigslist site and is asserting that 3TAPs is engaged in unauthorized access when it gathers up the information there and does something interesting with it, like put it on a map and make it more useful and more presentable in some ways. So in their lawsuit, 3TAPs has obtained a sort of a pro and con ruling here, where its motion to dismiss has been denied. It's good in some ways and bad in others. One of the more problematic aspects of the denial here is the court's interpretation of the Computer Fraud and Abuse Act as saying, well, if you've gone ahead and told someone that their IP addresses are not allowed to access your site, and then they route around that by changing their IP addresses, that's going to be unauthorized access under the CFAA. And so basically on that principle, the court has decided that Craigslist's action can continue. Evan, do you find this problematic?
Well, it's interesting. There's this question of whether or not it's a violation of the CFAA, and the big controversy comes whether it's a criminal violation of the CFAA to violate the terms of service in accessing a website. And what we have here in this decision is not that. The potential for liability under the CFAA comes here from doing something to circumvent a technological measure other than just, clicking through when you are misrepresenting or doing something else to make you violate the site's terms of service. Craigslist specifically tried to block the access by this party. That party spoofed the IP or used a different IP in some way to go ahead and gain that access. So what we have here is a situation where it's much more, there's much more to hang one's hat on when it comes to CFAA violation here than what there is in those other situations. So, I think that there's reason to be happy about it in that respect, but at the same time, it also, if you look at what Hani Fakhouri wrote on the EFF blog, and he was on the show a few weeks ago. He points out some of the downsides of a situation like this. And in his piece, he says, changing your IP address is simply not hacking. That's because masking your IP address is an easy, common thing to do. And there's plenty of legitimate reasons to do so. And those examples are easy to come by, privacy or whatever. So what Hani seems to be saying there is, shouldn't hacking be reserved to the more sophisticated actor? Liability for hacking be reserved to the more sophisticated actor? I see what he's saying, but I don't know where to draw that line. If you're going to make whether or not something is unlawful because it is easy to do, or wait, did I say that right? He seems to be saying that if it's easy to do, it should not be unlawful. Right. That's the implication of what he's saying there. I have a little bit of trouble with that because it would be relatively easy for me to walk by my neighbor's garage that happened, he left his door open, go in and steal their bike. That doesn't take any special knowledge or sophistication on my part, but nobody would argue that I shouldn't be criminally liable for stealing that bike. Now, I'm not trying to say that access to this information is perfectly isomorphic with stealing. Give me a break on that. I don't want to have people throwing tomatoes at me for that. But the whole point I'm trying to make is ease of commission should not be a factor in the determination of whether or not it's a criminal violation. So, it gives us things to talk about, this three taps decision. This case continues to give us things to talk about, all kinds of copyright, terms of service, CFAA issues.
Well, let's slice it a little differently and assume that perhaps the statute and courts are sophisticated enough that it would be a criminal violation if you've been put on notice that you're not authorized through a cease and desist letter, such as what Craigslist sent here. And through notification that your IP addresses are being blocked. If you were to then go and change your IP addresses, that seems to be sort of a more nefarious game of cat and mouse than the one that you'd be playing. One of the examples Hani Fakhouri gave is you might want to mask your IP address if you want to avoid price discrimination. So if you find that there's a site that's going to offer you a certain price if you're residing in one area and a different price if you're residing in another, and you're going to and run that by masking your IP address, then maybe the courts and the statutes would be able to distinguish between those two situations. What do you think, Jerry?
Well, I think the good news in this case is that the court didn't go as far as it could have gone, which is to say, just masking your IP address would be a violation, and that would mean that using ProXPN would be a violation. So I'm glad that they say, well, no, you've got to be blocked and put on notice. So that's good. But the problem with that is what that creates is a regime where you or Craigslist or whoever can put up a completely public website on the public internet on the web, but not you or you, and it's criminal if you try to come by here in a way that where you're masking your IP. I understand it, but I think what's really driving this is the reason that they want to block 3Taps, and that's because 3Taps is scraping all of their content. And I don't think they have a copyright claim, likely, because the content that's on there, number one, is not theirs to copyright; it's their users. And number two, it's just descriptions of apartments, like where it is, how much they're asking for rent, how many bedrooms it has. But still, we seem to think that there is some kind of property right here. That it seems kind of odd that some site like PadMapper, which uses the 3Taps data, can go scrape rent.com, apartments.com, Craigslist.com, and then create a new site that has all of this data verbatim, right, without anybody's permission, and Craigslist has no recourse. So that's what's driving this, and I think that the urge to sort of say, well, there's something that feels wrong about this. We need to address what seems like, Craigslist has a legitimate concern here, but we're doing it through the CFAA, and in the process maybe making bad law. That just feels a little forced.
Antone, do you think that there's a way that people who are, truly seeking to violate a website owner's rights can be swept up under the statute, and those who are seeking simply to mask their privacy or end run some economic restrictions, that they could be free to continue on with their IP masking?
Well, so I may be a little biased here because most of my career I've represented internet companies and therefore their interests, but from my point of view, and by that I mean private, for-profit enterprises. And it is so easy to forget that, for example, Facebook is a privately owned for-profit enterprise, and they're using it for free just because they let us. And they let us because they find ways to monetize us. And so that's a deal we make, and it's understandable. But so my view in the big picture has always been, our playground, our rules, and they are what they are. And these are actually excellent examples of what we dealt with at MySpace. What feels like an eternity ago, 2004, 2005. When we were, we're growing by 250,000 users a day, and we were like the social site. Unfortunately, tragic, distant history, and how the mighty have fallen. But regardless, we got to be the test case for a whole lot of these kinds of issues, most of which never got to be litigated because, as you know, if things ever even become or I should say, never got to be settled in court because things get to be litigated and then end up settling, and then there's no precedent there for anybody to rely on. There's no court decision for people to look to. But we had the exact same issue come up regarding scraping, and at that time, because we were the ones getting 250,000 new users a day, every little service, every app, everyone that was trying to sort of ride on that user base, and the explosion at the time, in between about 2003 and 2006, of social media, would try to scrape the hell out of whatever they could get off of people's MySpace profiles. And of course, we had terms of service that said, specifically, thou shalt not use, automated scripts or bots or anything to gather information from the site and use it for any other commercial purpose. In fact, even using the site at all for commercial purpose was, without our consent, was prohibited. And then people start yakking about selective enforcement and so on. True,
yeah, I mean,
guilty as charged, right? I mean, that's part of operating a site, is having to decide what you want on it, whom you want on it, and who you don't, and what you want to set in terms of, for example, Facebook's real name, real identity rule, which has been around forever. Sorry, you were saying?
I was going to ask a question. I wonder if Craigslist, and I know Craigslist surely doesn't want to do this, but if Craigslist created a login system where before you saw the ads, you had to log in. And would that make this a much clear-cut case at that point, where if you are circumventing logging in and then scraping, then it's a lot clearer how it fits into the CFAA, whatever you may think about the CFAA. But right now, it's just visiting a public website.
Right, and I think even under this decision, which is just an intermediate order at the district court level that allows the case to proceed, that some of the language that Antone was just mentioning, the statement in the terms of service that scripts or robots would not be authorized, that commercial use would not be permitted. I wonder how that would fare under this determination by the court, or under this court's reasoning that accessing a public website is not per se unauthorized. It seems to me like this court was saying something more than just the terms of service would be required to trigger that lack of authority. But again, that doesn't seem to have been squarely in front of the court here. Any thoughts, Antone?
I think there's a huge distinction to be drawn between civil liability versus criminal when we talk about this stuff. I mean, to me, the CFAA is extremely serious stuff. You're talking about, whether we talk about Aaron Swartz or Auerbach or whomever, people go to jail over things that are basically, considered the equivalent of breaking into someone's private home or business, and whether or not that does terrible damage, the intrusion is real and the consequences are severe. Versus having a civil liability or a case that upholds the enforceability of civil, call it civil contract law, essentially, when you enter any website and there are rules in terms of who they allow on and why and what how you have to behave if you violate those rules, and it's communicated and you can't argue that you didn't know about it. And, of course, that's just a tangent. We all know about the problem of people not reading TOS and not reading privacy policies, and it's been around forever. And it's also not unique. I mean, it happens with lease contracts, right? With the thing you sign when you check in at a hotel. There are so many examples of cell phones are a great one, where people just can't be bothered to read all that crap, and then something comes back to bite them, and then the question is this unconscionable because it was sort of foisted upon people? And I don't think there's not an obvious answer to that. I think in some cases maybe. But where I think this really, on the criminal side, where this really came to a head, in my view, was and I don't know if you guys talked about this a couple months ago, but the Auerbach Weave case, where
Sure.
in his case, he said, look, I didn't hack anything. I didn't break into anything that was, not made available to the public. It was a public API, and it was AT&T's kind of stupidity or whatever error to leave it open for me to do what I did. And I don't disagree with that. At the same time, I also don't see that having a lock that someone has to pick or break to enter needs to be an absolute prerequisite for criminal liability under the CFAA. I think Oren Kerr, by the way, has written a lot of really great stuff on this. I don't know if you read him, but I'm a big fan of his stuff on the Volokh conspiracy.
Yes.
And he actually
of the very, very early law blogs.
Yeah, and I love that site, even though I don't always agree with all the opinions expressed there. There's a wide range of them, but what I love about Kerr in particular is he's one of the rare people on the planet that's actually been, both a prosecutor and a defense attorney on issues relating to criminal computer law in the U.S. There are very, very few people that I think qualify for that. And he's a professor and a commentator who's willing to talk about it. And so,
Right.
So he, for example, was defended Lori Drew in that whole thing with where they tried to use the CFAA to go after her for using MySpace to essentially hound and torment a teenage girl to the point of suicide. And it was one of those great examples of bad facts make bad law. The or well, actually, in this case, I guess it came out okay, but only because the judge set aside the jury's verdict. How often does that happen? I mean, it was incredibly rare. But the jury was ready to convict on the basis that because she violated the MySpace terms of service, that alone was enough to make her liable, of a serious, a felony under the CFAA. And that's caused a lot of people to be very alarmed and say, that's nuts. So now then you get the posts that say, oh my God, if I use a fake name on my eHarmony profile, then that means I'm committing a federal felony. Well, no, I mean, the concern is legitimate. The reaction, of course, is out of proportion. But the issue is clearly there, and it's an important one this question of exceeding authorized access. Oh, there's one phone I didn't mute. I'm sorry. I'll wrap up and mute for a second so you guys can continue undisturbed.
All right. Well, unless there are any final thoughts on the CFAA, I'd love to get into some other policy considerations. Jerry, anything to wrap up here?
No, I think we've said it all. I think it's CFAA just. I like what Anton was saying, my house, my rules. That sort of makes sense to all of us on a gut level. But then you have all these applications that sort of raise your heckle. So with Lori Drew, yes, they were ready to convict her for violating terms of service, but that's what my house, my rules means. So yeah, I think the CFAA is a law is probably a little too broad.
Yes. So we will continue to look for reform on that front, and either in Washington or in judicial interpretations of the law. Let's move on to some issues on the legislation and policy front.
Yeah. Here we go.
Yay. Evan, I hope you got some good dancing in there as we played our little bumper. Evan, I hope you're excited too that here it is, August 26, 2013, and we are talking about Bitcoin.
I know. And yeah, I mean, and we have in the conversation with us somebody who's really spending a lot of time extolling I won't say the virtues of it, but the positive way the future might go. I mean, Jerry, what Denise is talking about, I think it was in 2011, I said, a year from now, we won't even be talking about Bitcoin. I was a skeptic. So thanks for, making me, have to contradict myself or whatever to go back on that. So, right, here we are, yes. Bitcoin. Let's talk about it.
It's fascinating stuff, and it just gets more and more fascinating every day with recently a judge ruling that the SEC could pursue an alleged Ponzi scammer who used Bitcoin as the mode of transaction here, and the court there found yes, it's not cash, it's not the kind of currency that we're used to, but it's currency, and so yes, the SEC can investigate and pursue. So I guess that's not really a huge surprise because certainly a lot of transactions are being done in the Bitcoin market these days. Jerry, what I'm worried about or concerned about, and I am kind of tongue-in-cheek because I've read the wonderful things you've been writing about Bitcoin lately, but there is a lot of concern about whether someone like Saul Goodman is going to be the primary user of Bitcoin. Saul of Better Call Saul fame on Breaking Bad, that he's the guy who's gonna, fix up your money problems and make sure that the millions that you've made illegally come out squeaky clean. I guess in Washington, there's a lot of concern over this too, is there not?
Yeah, there sure is. I think that's a main concern at the moment surrounding Bitcoin. But I think that's a concern that you have about any new payment system, and it's something that regulators are slowly beginning to figure out how the law applies to Bitcoin, and they are applying it. It's interesting. I think I have not yet seen Breaking Bad. It is on my list to start with episode 1. So I don't know who Saul is, but he sounds like not a good guy. And
He's
so somebody,
actually he's one of the best characters in the show. He's the lawyer character in the show.
he's like the money
And-
launderer, right? Yeah.
Yeah, and I've got to warn you that a week ago on our episode, we were covering how Breaking Bad was looking to be one of the most illegally downloaded shows of the year with its latest season coming out. And I started watching it at episode 1. And I'm warning you that the show itself is as addictive as the substances that it documents. So
That's what I'm worried about.
Yeah, you're going to have to throw yourself into it when you do.
Well, somebody like Saul, looking to choose a way to move money around illegally online, probably isn't going to choose Bitcoin. When regulators and folks in Congress are looking at right now, they're looking at virtual currencies. In fact, this is when the Homeland Security Committee in the Senate issued a letter to DHS asking for information. They're investigating virtual currencies. And it's important to know there's two kinds of virtual currencies. There are centralized virtual currencies and decentralized virtual currencies. So Bitcoin is decentralized, I'm sure you all know, because nobody owns it, nobody runs it, nobody controls it. It is a peer-to-peer network, right? Just a lot like BitTorrent, right? It's decentralized. Then you have centralized currencies that are more like the Napsters of currencies, right? Which means it's a company that sets up and creates virtual tokens. So for example, you have Amazon coins, Facebook points, so you have a company issues this currency and you can give them dollars. They will give you, exchange those for those points, and then you can either buy things with those points or exchange those points with other users. Well, you have some other centralized virtual currencies that essentially are designed for criminal enterprise. Recently, you had Liberty Reserve is a company that was shut down by the DHS, I think it was about 2 months ago. And this is something that Brian Krebs had been covering for a long time. The entire trade in stolen credit card numbers in the hacker underground was being done through Liberty Reserve dollars. And Liberty Reserve was being used for all sorts of other money laundering related to drug trafficking and even human trafficking. And the reason they choose that centralized currency is because, again, it's designed for money laundering. When you open an account, they do not ask to verify your identification. You can use any name, they don't verify it. And they really don't keep as few records as possible. And so it's perfect for that use. Whereas Bitcoin, yes, Bitcoin is pseudonymous. It's not anonymous like a lot of people think it is. But for Bitcoin to work as a distributed currency, you have to employ a completely public ledger of all transactions that ever happened in the history of Bitcoin. And so actually, law enforcement has greater visibility into the Bitcoin economy than they do into some of these centralized currencies. So I like to point out that somebody like Saul probably would choose some of these other currencies as opposed to Bitcoin. Although, yes, you could definitely use Bitcoin to do illegal things.
All right, I'm going to let you guys continue exploring the nuances of this on your own for a few minutes. I need to run to take care of something, but I will be back before the end of the show. So have fun, and I'll see you in a minute.
All right, see you in a few.
All right.
So, Jerry, this whole idea that the whole history of all the transactions, are that in order to use Bitcoin successfully, you've got to be able to. Everyone has to have access to every Bitcoin transaction that's taken place from the history of time, since the very first Bitcoin transaction. Can you talk a little bit more about how that could actually, in practice, be decipherable to law enforcement or in the process of civil litigation and discovery, something like that? I mean, isn't it so complex that it would still be difficult to trace these transactions nonetheless?
Right. So as I said, Bitcoin is pseudonymous. It's not anonymous, right? So when you think about anonymous currency, cash, like dollar bills, are anonymous in the sense that, I could find you on Craigslist. I don't know who you are. We agree to meet on some street corner. I give you cash. You give me whatever goods. We go our separate ways. There is, I don't know what your identity is. You don't know mine. We never see each other again. There's no record of that transaction. That's a completely anonymous form of payment, a completely anonymous transaction. On the other end, you have something like credit card transactions, where in order to have a credit card, you are identified. to your credit card company. They know who you are, and they keep a record of every transaction. So if the government or in civil litigation there's discovery, they can go to that credit card company and know exactly who you are and how much you spent on what, or at least where, right? So those are two ends. Bitcoin is somewhere in the middle, where all transactions are recorded in a public ledger that's visible to everybody, but the identities of who is transacting with whom is, there's no identification. It's just a number, right? You have a Bitcoin address, I have a Bitcoin address, so you see, this Bitcoin address sent this much to this Bitcoin address, and so you have all of those. What it takes, honestly, for government or anybody is to put a name, put an identity to a particular Bitcoin address. Once you do that, you can figure out, okay, well, this person made his transaction. You could go to them and say, who did you transact with? Now, maybe you've got the identity of a second person that they transacted with. And you can just keep doing it on down the line, basically de-identifying everybody. Now, this is not going to be 100%. You can't do this for the entire blockchain, but it is a technique. It is a pattern analysis technique that law enforcement might employ. So today, the regulations that you're seeing are anti-money laundering regulations that the Treasury Department is seeking to make sure that Bitcoin businesses are complying with, that require them to identify their customers so that they do know what is the name of the person when they give them a Bitcoin address.
Anton, do you think we're beyond the point where the government will ever be able to successfully shut it down altogether? And we see federal district judges saying Bitcoin is money. If you're going to be on the side of the feds and want it to go away, has that ship sailed and now it's just a matter of regulating it for money laundering and tax and other tax issues and all that stuff? What do you think, Anton?
I just want to say one thing, that I'm not sure at this point that you can say that the feds want it to go away. I think that the federal government, especially folks in Congress, are obviously concerned about the money laundering aspects, but I think they're coming around to saying, like, oh, this is a really interesting, disruptive, innovative technology, that there are lots of very legitimate businesses backed by Peter Thiel, Sequoia Capital, Union Square partners are putting a lot of money into this. There's something here. Sure, I think the money laundering regulators are like, oh, this is something else we have to deal with. We have our plate full. So they kind of feel like we don't really need this, but I don't think they want to kill it. At least that's not the sense I get just yet.
Anton, you back among the living?
Yeah, can you hear me now?
Yeah, sounds good. What do you think about regulation and its objectives?
Well, regulation versus killing it, is a really interesting question. I think that the most ardent advocates would want neither, right? They want it to exist independent of a government and independent, in particular, of any nation's government. And understandably, I just think that's not realistic. Frankly, if I were working at the government, I could tell you I just want it to go away. It's just one more thing to deal with, right? Because how does the government selfishly, from its point of view, stand to benefit from it? It probably doesn't. Being pragmatic about it, if it seems like there's no way it is going away, or similar cryptocurrencies. Let's say that also that add the disclaimer that Bitcoin is the first, but there may be others that have succeeded ultimately as the cryptocurrencies of choice. Regardless, I think that governments. Sure, they're concerned about money laundering. Sure, they're concerned about terrorism. I think, frankly, all of it pales in comparison to tax evasion. And again, pure self-interest. The government, what it needs, the Treasury needs to be full. Period. The most invasive laws we've ever seen on the front of privacy are basically IRS, tax regulations. I like to remind people that when we talk about the NSA and so forth and these privacy issues vis-a-vis the federal government, not only do we have to provide the most sensitive financial information about our personal lives and business affairs every year, it's like the only crime. This is one of those things from law school, right? It's like one of the only things where you have to report yourself, and if you don't, it's a crime. It's that serious. It's taken that seriously by government, and frankly, I don't blame them. Whether the rates are too high or too low or whatever, they need to collect the taxes. And going back to my sort of undergrad econ major roots, people rationally maximizing their income most of them probably would go to all kinds of lengths to avoid having to pay those taxes. And I can't think of many better ways to do it than to try to get it out of U.S. dollars online in some form as quickly as possible, and spend it, if not exclusively, then primarily through those other channels to avoid Uncle Sam seeing it. Now, understanding, of course, that, as Jerry was saying, there are lots of ways in which that is not probably going to be an easy thing to do. But I think that the feds, if they're smart, will engage and try to figure out how to regulate in a way that doesn't kill it, because frankly, if they kill it, others will just probably continue to spring up. That might, if anything, be harder to get their arms around. But they'll have to have some kind of connection there that allows for transparency or accountability on a certain level that frankly is at odds with the reason why many people would want to use something like Bitcoin. And I don't think there's an easy answer there. I think that, privacy, and I've said this a million times with regard to all privacy issues, including NSA stuff, encryption, you name it. Privacy to one person is the lack of transparency to another. It's true between individuals and businesses and government, and there's no easy answer there.
It's almost as if the government's going to come by and in a certain way legitimize it or whatever. It takes away the cool factor from it as well, from being this separate currency, totally distributed and all that. And Anton, I'm glad you kind of framed it in the context of tax evasion, because it's my understanding that one of the big driving factors in the war on drugs is the government's concern in a lack of tax revenue that it's getting from a lot of the transactions that happen in the drug trade. So, Jerry, how could we say that the vigor that the government may take in regulating Bitcoin would be any different than the vigor it has used in fighting the war on drugs? Is there any comparison to be made there?
No, but I would say a couple of things. First of all, if the government's concerned about losing tax revenue because of the war on drugs, if it legalized drugs, then it would be perfectly legal income that they could tax. So that's one easy solution to their problem, if that's their problem. But I would say as far as tax evasion and Bitcoin, yeah, that's certainly a concern that I think we'll see down the line. I think this is going to come in stages, right? So the first immediate concern is, can this be used the way centralized digital currencies are for money laundering, for human trafficking, et cetera, right? So that's one. But eventually, yes, I think the tax issue will come up. GAO recently put out a report at the behest of the Senate Finance Committee on Bitcoin and taxation. And they basically said, well, there's not enough data here. IRS should look at its rules mainly about capital gains. If you invest in Bitcoin, so say you buy some Bitcoins now, and then you sell them a year from now, and they've gone up in price, how do you report that in your taxes? It's not very clear. They should issue guidance. But the fact is that the Bitcoin economy right now is $1 billion economy, and that is just peanuts to the government. I think if and when Bitcoin does grow larger, we will see that interest. But ultimately, it seems to me that for this to really be a problem for the government collecting taxes, you're going to have people being paid their incomes in Bitcoin, because otherwise, if you're being paid in dollars, well, then you have withholding right there. You've got reporting by employers. So converting it to Bitcoin later really doesn't help you. It might help you to evade sales taxes, perhaps. But so you've got that. But even if you are taking your income in Bitcoin, you would have the same, law enforcement would have the same tools it has today. If you have a $2 million mansion and a Tesla and a lot of different things, and you have no income to show for it, there are going to be questions raised. Government is going to ask questions, and so it's going to be no different than it is today.
I don't want to sound too obsessed on trying to kill Bitcoin because, I mean, the technology is fascinating.
It's anti-American, all right.
Right. Yeah, sure. Well, that actually is where, I mean, it's not totally unrelated to what I was wanting to take this conversation. I mean, I'm wondering, Jerry, if you've given any thought to, or really my question should be, what extent have you given the thought that Bitcoin may violate the Constitution? It's in the Constitution that the federal government has the authority to coin money. Is there any legislation that could kill this, or any way of teeing this issue up to where the Constitution could be used to challenge the efficacy of the Bitcoin architecture, at least as it pertains to the U.S. transactions?
Yeah, that's been looked at quite extensively. There's a fantastic article by, I forget his first name, but Greenberg is his last name, that looked at all the different ways that Bitcoin could be regulated. The first thing he asked is, can you have a private currency, or is that unconstitutional? And the answer is no, it's not unconstitutional. What is illegal, we saw this with the Liberty Dollar case, is you can't issue a currency that looks too much like the U.S. currency. But we have private money all around us, right? From Berkeley shares to Brooklyn bucks, Facebook points. These are all private money. So private money is perfectly constitutional or perfectly legal. There's nothing in the Constitution that would stop you. What all the Constitution says is that Congress is the branch that has the power to mint official U.S. coins. So the executive doesn't have it, the judiciary doesn't have it. It is Congress who can do that, and by how much. It does not exclude others from issuing their own private money. It just can't look like U.S. dollars, or they can't make people believe they are U.S. dollars. That's all.
Does that sound right, Antone? Because we wouldn't want to be breaking the law by playing Monopoly, right? We want to make sure that that's lawful.
Well, that was one of the first things that I thought of when I heard about Bitcoin. And then the more I thought about it, the more, just common sense sort of said to me, well, how is it any different than if I want to, buy Canadian dollars? I mean, foreign currencies it's not illegal to buy and own and trade in and conduct commerce in a variety of foreign currencies. The real issue there is just practicality and who's going to accept it and what sort of value do you get for it. And maybe if it were a physical product and it were being created here in the U.S., then it might be a bigger concern. It sounds like the research has been done. Frankly, I'm not an expert on that, and I trust that. But even if there were a law supposedly saying you can't print your own dollars, let's say in the U.S., this is a distributed, decentralized system that was created, as far as I know, in Japan, and is worldwide. And so, if anything, I would think the regulation of it would fall under regulation of trade in foreign currencies. But that's a sort of
just to be clear, the reason
gut reaction.
The reason that the Constitution mentions or gives Congress the power to coin money is because before the Constitution, the states each coin their own money. So the reason it's in there is because by saying Congress is the only one with the power to coin money, it means the states cannot. That's the reason, right? But again, we have all sorts of different private money.
Yeah, and the language in the Constitution. Oh, Denise is back. Hi, Denise.
Yeah, I'm back. I just wanted to say hi. In light of our conversation, it must have seemed like my second cell phone was ringing, but I had a summer camp handoff to facilitate there.
Good. We're just wrapping up our conversation about Bitcoin here. We're just kind of going over the finer points of whether the Constitution would prohibit it. That's what I was thinking a couple of years ago, and because what I had imagined that if the government wanted to do something with this, it could enact a law that says any contract, anybody who enters into a contract where the basis of the consideration is a Bitcoin transfer, that contract would be unenforceable in a court. And I was just thinking that as a potential way of making people less interested in using Bitcoin. That wouldn't have much bearing if the subject matter of the contract was unlawful to begin with. You don't have people filing lawsuits over failed drug transactions, where you pay money and the drugs don't show up. So it might have a limited effect, but that's kind of the point that I was trying to drive at. But we've probably talked about Bitcoin enough at this point. We're still harping on it now that you're back, Denise. I think we've probably exhausted this one.
All right. Should we do our resources and tip of the week? Because we've got some good ones.
No objection from me.
All right. Well, our resources are, as they often are, thanks to our great guests today. I have one each from each of our guests. First, over at the Wall Street Journal, Antone published an article last year that I think is very, very useful to anyone starting a company or in the startup arena at all. And it is 5 IP mistakes that startups should avoid. So definitely go check this out. Some things that you might have thought of before or maybe not. Getting into how you can avoid the problem that Facebook had with the Winklevi, for example, how you can know exactly what kind of IP that you're dealing with, all kinds of good information there Antone has provided us. So do go check that out. It is in our discussion points at delicious.com/thisweekinlaw/224. And then our second resource of the week, if you have not had enough of the Bitcoin discussion, is a wonderful primer that Jerry has co-authored for policymakers about Bitcoin. But it's wonderfully clearly written. You don't need to be scared off from it, thinking that it's aimed at folks in Washington in policy-making kind of positions, because it's very understandable and accessible. So I encourage you to go check it out. Andrea Castillo is Jerry's co-author. They go through the history of Bitcoin. They go through the technology of it and all of the policy considerations around it. So a really wonderful resource there for anybody trying to get a better handle on the world of Bitcoin. Taking us to our tip of the week, I'm really excited about our tip of the week. It should be fairly obvious that if you are a music company out there protecting your copyrights on YouTube, Content ID system flags something and you go, oh, we better send a notice and takedown, that you'd better do your homework if the person you're sending your notice to is Larry Lessig. And that's what happened here. I know that Evan, I feel like we, on the show, we actually may have played clips from the talk that got taken down. What happened was Professor Lessig gave a talk in Japan, I believe it was, at a conference where he highlighted some clips that illustrated the mashup culture on YouTube. And what happened was it started with one particular mashup that took the song Listomania and put it against some clips from the Breakfast Club movie. And then there were tons and tons of responsive videos after that. And I'm wondering, I actually have a couple of clips I would love to play if we could that shows what went on here. Alex, do you think we could do that?
Want to get this taken down?
Yeah, we can do that.
Yeah. Oh, Shannon's with us. Hello, Shannon. So if you look in the rundown, if we start at 4:40, just let me know, and I'll continue talking about what happened here. So these clips very nicely illustrate how mashups sort of play off one another, that one might begin and then other versions might get taken up. And this is what Professor Lessig was highlighting in his talk. And he very shortly began hearing from the various rights holders. This particular one that he has sued is an Australian record company called Liberation Music, which demanded that he take down the video of his talk. And they did the notice and takedown procedure dance for a bit, and then Professor Lessig has actually affirmatively filed suit with the help of EFF and the Jones Day firm in San Francisco, asserting that what he's doing here is fair use. He's seeking his costs and attorney's fees, and just isn't going to roll over on this. So it's a pretty interesting development, and certainly, not the guy to come after if you're going to file a notice and take down and not do your homework as to what could be fair use.
Go ahead, Jerry.
Oh, I just was going to say that it almost makes you feel bad for this company that just stepped on a landmine.
Yeah. They must not have known what they were doing.
There appears to be some issue as to whether they're even the licensee, the one to be able to do it. I mean, that's indicated from EFF's post about it. And, I was doing a little bit of research on Liberation Music, and I can't find any published connection between them and Phoenix, the band.
The band, yeah.
Okay, start this at 4:20.
Thank you. Yes, that'd be great. Or
4:20 is always a good time to start.
But it's great content. I'm going to give you a little bit of it. So here he is beginning.
I wanted to make an observation about the way remix culture seems to be evolving.
So what he does is he begins to tell us about these 3 videos.
Here we go.
This is this fantastic Brat Pack remix set to this Mania, which of course spread virally, hugely successful. And then some people from Brooklyn saw it. They decided they wanted to do the same.
I'm feeling so nostalgic for 2009 right now.
Yeah. So you get the idea.
People from San Francisco saw it, and San Francisco's thought they had.
Yes. Many, many different iterations of that came online. And I think that Professor Lessig has referenced that phenomenon in a number of talks, including the TED one we just pulled up, which is still online, and the one in Japan that is now the subject of this lawsuit. So we'll keep an eye on that. Professor Lessig is doing this to hopefully clarify what it means to push back on a DMCA takedown notice and assert your fair use rights and make some sense out of that whole process through the lawsuit. So we wish him well, and we caution you that if you're going to send those takedown notices, you definitely need to do your homework, particularly if Larry Lessig is on the other side. So yes, found that quite a wonderful bit of serendipity in the week's news. Guys, this has been really wonderfully informative and enlightening. I have enjoyed every minute of the show. I wish we could go on further, but we do have to bring this one in for a landing. I think that we need to drop a second MCLE passphrase into the show. So let's make Phoenix the name of the band that we were just listening to. That passphrase for anyone who needs to demonstrate that they have listened along with us this entire time for continuing legal education credit. And I just can't thank you guys enough for taking the time out of your Friday to join us. Anton, it's such a pleasure to meet and speak with you.
Oh, likewise. It's a fascinating conversation.
Anton's very prolific on Twitter. He's Anton Johnson there, so you should definitely follow him. You have a Google Plus page, too. Anything else you want to plug, Anton, before we sign off?
Plug away. No, I'm pretty noisy in social media, for better and for worse. But in the offline realm, I'm going to be speaking at a social media law conference next month in Seattle, which actually, and this is the first time I've attended, let alone spoken there. It sounds like a really interesting event if you happen to be able to make it there. September, I think, 16th, 17th from Law Seminars International.
Cool. Yeah, very topical area of the law for us, for sure. So we'll be sure to check in on that. Let us know about interesting panels and things we might want to follow there. Jerry, you're doing such great work and writing. It's always a pleasure to have you on the show. We're so glad you could join us again today. In addition to the primer you've just authored, anything else that you feel that people need to know about out there?
I would invite everybody listening to check out Surprisingly Free, which is the podcast I do every week about technology policy. And we have some great guests, some great authors. Last week we had Tim Lee, who just started, who's from Ars Technica, just moved over to the Washington Post and started a new tech block there. We had him. In the past, we've had all sorts of interesting people, from Vint Cerf to all sorts of people. So check it out, Surprisingly Free.
Yeah, it's wonderful. You guys definitely, if you have any love for this show, you will love Surprisingly Free. And Evan, we are surprisingly through another episode of This Week in Law. It's been really fun.
It has, hasn't it? And there's our 6 degrees of separation with Vint Cerf, Jared. Like that.
Yeah, there we go.
Yeah. But yeah, Denise,
I've been looking for that for a while.
Right. It's Vint Cerf is like Kevin Bacon in so many ways.
Yes.
But this is, this has been great. Isn't it awesome, Denise? We get to, we have the privilege to talk to such smart people. It really is great. Today's conversation has been fascinating. Once again, I learned more than what I was even able to contribute. So it's been a great time. So looking forward to next week.
Yeah, me too. And if you would like to join us next week, we record the show every Friday at 11 o'clock Pacific Time, 1800 UTC at twit.tv. You can join us live, jump in the IRC, and play along with us. If that doesn't work in your schedule, head on over to twit.tv/twill. Our entire archive of shows is there, as are, I think, just the most recent ones over at youtube.com/thisweekinlaw. So you can find us on iTunes. You can find us on Roku, however you like to consume your online video entertainment. We will be there for you. And we love hearing from you between the shows. In fact, we could not do this show without hearing from you between the shows. And we'll do that wherever you'd like to engage us. We have a Facebook page, a Google Plus page. Evan and I are both on Twitter, and we love hearing from you there. He's Internet Cases. I'm D. Howell over there. Plus, you can hit us up in email. I can't guarantee that it won't be stored or read by third parties unknown to us, but if you're game, we are. You can hit me up at Denise at twit.tv. Evan is Evan at twit.tv. And until the next week, we have enjoyed being here with you. We hope you are safe out there on the web. We'll talk to you soon. Take care.